Hello, doctors. I'm Dr. Chris Rapoff of DC QME Continuing Education, and welcome to this week's Case Law Update. A couple questions for you before we begin. Have you ever provided an opinion in a QME report that, one, doesn't include the review of medical records pertaining to a prior injury to a claimed body part that you had in your possession? Or two, that you based your opinion or conclusion that the body part you examined, quote, looked normal? That was your answer with no analysis? Both of these rookie mistakes were made by both the PTP and the QME in the Ravelis versus Dadul textiles. So what the appeals board had to say about this? I think you already know the answer, but let's go on and take a look. So let's get into this case. Here we have the applicant, Mr. Ravelis. He's seeking reconsideration of a findings and award that was issued by the workers' compensation law judge in July of 2023. Now, the law judge found that the applicant, Mr. Ravelis, did not sustain any permanent disability as a result of an injury he sustained in December of 2020 in an industrial injury. Mr. Ravelis' attorney contended that the reports from the orthopedic qualified medical examiner were not substantial medical evidence regarding his permanent disability and should not be the basis for the workers' compensation judge's opinion. Some background. Mr. Ravelis claimed injury to his cervical spine, thoracic spine, lumbar spine, left shoulder, left wrist, left ankle, and left foot while he was employed by Dadul's Textiles as a driver or a loader in December of 2020. Now, Mr. Ravelis initially received treatment from his primary treating physician in December of 2021. Those diagnoses that included thoracic, cervical, and lumbar spine strain sprain, left shoulder and wrist strain sprain, left hand strain, left knee sprain, and left foot and ankle sprain. The PTP noted that Mr. Ravelis had, quote, a prior work injury in 2008 involving the right shoulder. The patient fully recovered. He also stated that prior to related accidents and injuries, the patient denies prior related industrial injuries or accidents. Mr. Ravelis denies prior related treatment for any industrial injuries or accidents. The PTP later noted that at the time of this examination, there were no medical records available for my review. Upon evaluating Mr. Ravelis in December of 2021, the QME based his examination of Mr. Ravelis on a description of his injury, and his symptoms included. He said the present complaints of posterior neck pain consistent of a constant achy pain, complaints regarding his left shoulder consistent of constant global aching pain. Examination of the left shoulder reveals a normal appearance without muscle wasting, instability, or tenderness. He also indicated at various times he abducts and forward flexes the shoulder from 0 to 100 degrees, strongly stopping suddenly and complaining of pain. But he said he's seen to abduct and forward flex the left shoulder from 0 to 180 without pain during the course of the examination. He internally and externally rotates the left shoulder to 90 degrees, and he also extends and adducts the left shoulder to 50 degrees, intermittently complaining of pain during the entire ranges of motion. So the QME concluded in its diagnoses that, quote, complaints of left shoulder pain demonstrating intermittent pain, complaints of normal range of motion without any neurologic or mechanical deficit. The QME then stated that Mr. Ravelis has no objective abnormalities regarding his neck, back, left arm, or left leg to support his subjective complaints, and he should therefore be awarded 0% whole person impairment. Now, the QME's review of medical records included a January 2021 note of a left shoulder MRI, and the MRI was interpreted by a radiologist, and the radiologist stated that there was moderate subscapularis tendinopathy with intrasubstance tearing, And he noted that the supraspinatus and infraspinatus had degrees of tendinopathy. And there was also a split tear of the long head of the biceps tendon. In addition, intra-articular portion was incompletely evaluated. So it was a pretty substantial MRI result. So now in February of 2022, the PTP determined that Mr. Ravelis had reached maximum medical improvement or permanent stationary status. So he concluded that the applicant had, get this, 5% cervical spine whole person impairment, 5% lumbar spine whole person impairment, 7% left shoulder whole person impairment, 10% left wrist whole person, 3% left ankle and foot whole person, and 3% pain add-on. Then with regard to apportionment, the PTP indicated that 20% of the patient's cervical spine, lumbar spine, and left shoulder, left wrist, and left ankle impairments were apportioned to a non-industrial cause, and 80% to the injury at hand in December of 2020. PTP also noted that he had reviewed the January 2021 left shoulder MRI that the QME did not, and the April 2021 EMG nerve conduction velocity report, and a December 2021 report of the QME that he later stated no other medical and/or diagnostic records were available for review at this time. So again, we have a lack of records review due to a lack of records being produced for the QME from the doctor. Okay, so now the QME was finally provided additional medical records to review. And then in March of 2022, he did indicate in a supplemental report that, quote, after reviewing these forwarded medical records, I see no reason to change my opinions as expressed in my initial qualified medical evaluation. Now, that's very interesting with all the additional information he was finally provided. Now, these parties did proceed to trial in March of 2023, and they stipulated that Mr. Ravelis had sustained an injury that was arising out of and occurring in the course of his employment to his neck, mid back, low back, left shoulder, left wrist, left ankle, and left foot. And then the trial was continued for further testimony by Mr. Ravelis. In June of 2023, the matter was finally submitted for a decision. So as the appeals board began their discussion in their ruling, they stated that it had long been the law that in order to constitute substantial medical evidence, a medical opinion must be based on pertinent facts and on an adequate exam and history, and must set forth the reasoning behind the physician's opinion, not merely his or her conclusions. And a mere conclusion does not furnish a basis for a finding. Now, a medical opinion is not substantial medical evidence if it is based on inadequate medical histories or exams. Now, in her initial opinion and decision, the workers' compensation judge stated that the PTP had not reviewed the medical records pertaining to the applicant's prior motor vehicle accidents. In that context, it's important to review a 2016 medical treatment report from a treating chiropractor for one of these injuries that he had sustained in an MVA. They stated that Mr. Ravelis was involved in an automobile collision in 2016 involving two vehicles. Now, they indicated the patient is experiencing cervical pain radiating in the left upper extremity, which bothers him constantly between 76 and 100% of the time. They also described the discomfort as being dull and tingly, and Mr. Ravelis stated that his symptoms appear to be getting worse with time. They also indicated that the average intensity of his neck was a 7 out of 10 on the VAS scale. And also, Mr. Ravelis had explained that his symptoms had moderately interfered with his work and social activities. He stated also that he had neck problems ever since the auto accident, and they stated that his neck problem was from the MVA. Now, when questioned as to the severity of his symptoms, the chiropractor responded that he believes the severity was severe. And when questioned if there was anything else that he could be aware of, Mr. Ravelis stated that there was nothing more pertinent. Now, even before we get into the ruling, I think you can already surmise or guess what is going to happen here. But the appeals board did finally say that they reviewed the reports from the PTP and they did agree with the workers' compensation judge that it did not appear that the PTP was aware of the applicant's prior MVAs, and he didn't review any medical records addressing the result of those accidents. So the PTP's opinions, you guessed it, are based on inadequate medical history and do not constitute substantial medical evidence. Now, the appeals board also said that regarding the reports from the QME that we just discussed, the QME said that Mr. Ravelis complained of constant global left shoulder aching pain, and then said Mr. Ravelis was able to do all the activities of daily living, and that upon the exam, his left shoulder looked normal without any instability or tenderness. However, the QME's review of the medical record included the left shoulder MRI that showed some quite substantial problems in that MRI result. So they indicated, the appeals board, that the QME statement that the applicant's left shoulder looked normal is not consistent with the left shoulder condition that was identified on the MRI. They also said that the QME didn't provide any analysis or any reasoning as to his conclusion that the applicant's left shoulder looked normal. It was just that it looked normal. So after they reviewed the MRI, an absent explanation or a basis of his opinion and his inconsistency with the MRI, they indicated and ruled that the QME's report wasn't substantial medical evidence either regarding the left shoulder condition, nor the issue of a disability caused by that injury. So any award, order, or decision of the appeals board must be substantiated by substantial medical evidence. And we get back to that once again. In their ruling then, they basically concluded that, as they had discussed, that the trial does not contain substantial evidence on the issue of disability caused by Mr. Ravelis' December 2020 injury. And based on that fact, the record must be further developed, and they did grant reconsideration, rescinded the findings and award, and returned the matter back to the workers' compensation judge for further proceedings that are consistent with this opinion, so they can issue a new decision from which any aggrieved person may timely seek reconsideration. So here we have a situation where medical records were not provided, even though they existed, and therefore there's a delay in the resolution of this case. Here again, we have an issue of a report not qualifying as substantial medical evidence. In this case, the PTP was not provided the adequate medical records of a pre-existing condition from an MVA. Not his fault. But the QME, basing his opinion on a left shoulder that he reported, quote, looked normal. Not a good look there. So the appeals board sent this back to the workers' compensation judge to issue a new decision after those issues were addressed and corrected. This is just another reminder of how important it is for a QME to pay attention to detail and not just provide a conclusory opinion, but one that provides the how and the why of your opinions and in your opinions. So once again, doctors, I'm Dr. Chris Rapoff, and I wanted to thank you again for taking the time to join me in this presentation. I hope you enjoyed it, and I look forward to some other interesting cases with you again soon. Until then, take care.